let's go back to our earlier interview. Of course, the Expropriation Act, as we said, highly contentious here in the country, continuing to ruffle some feathers. So that land market legislation, as we said, is aimed at addressing long-standing issues of land inequality and providing a framework for the expropriation of land without compensation. So, of course, some opposition parties, the Democratic Alliance, vowing to take legal action against President Cyril Ramaphosa. Let's bring back political analyst Bongani Mahlangu. I hope, Mr. Mahlangu, you're able to hear me this time around. I did say, judging from the DA presser, it seems like the main argument was that over procedure.
Yes, greetings to you once again, and also the viewers once again. Yes, so from the minister, so the input that the minister made at yesterday's press briefing, the argument is the procedure, rather the incoherence in procedure. So he's arguing that the policy, sections of the policy are incoherent to each other. So he makes citation of Section 7, Section 8, Section 19, and Section 21, that these sections which speak of the notice of intention to expropriate, notice of expropriation, payment of municipal rates, taxes, and others, and mediation and determination by a court, that there is no coherence from all these sections. So then that means that if, let's say, this is true, because it could be a subject of legal interpretation, but if it were true and these things were then remedied, these sections were then remedied, he would not have any problem with regards to implementation of the Act in its entirety, because he's making just citation of those two. So that means he would continue with what is in Chapter 2 of the Expropriation Bill or Act, especially Section 3, which is the section that gives powers to the minister to expropriate, because this Act in itself is now a mandate of public works and must be implemented by the minister.
I mean, Minister John Steenhuisen also saying they were not informed accordingly, and he spoke about the section that speaks to a consensus in the statement of intent.
Yes, so now Steenhuisen, as the political leader of the EFF, the Democratic Alliance, so his argument is a political argument, and the political argument is solely based on the statement of intent. So he makes citation of Section 19 of the statement of intent, which speaks to sufficient consensus. So he argues that they were not adequately engaged, they were ignored in some parts, so meaning there was no engagement at all that was sufficient, so there was no sufficient consensus. Hence he makes that argument. He goes further to say that they will then issue a dispute with regards to how everything has unfolded up until this point. So that is then Section 20 that he makes citation of with regards to dispute resolution or breaking of a deadlock. But then what he also goes further on to say, which is now the veiled threat that a lot of people would have missed, is that if then the DA does not find satisfaction from exercising or evoking this section in the statement of intent, what the DA might do is that they might not support the budget speech or the budget. They might also not support the adoption of the medium-term development plan, which is the strategic plan for government for the next 5 years. And if those two documents have not been supported, or policy positions, because the budget is a policy, have not been supported, we all know that there will be certain consequences with regards to the operations of the state.
And I mean, the biggest issue is around what looks to be an ultimatum relating to the implementation of budgets, if I heard that correctly. Is that the main threat of what we heard come out of this press briefing?
Yes, so that basically is the main threat, because if you listen to it, the only thing is said that I just got off the plane, I've not been adequately briefed. As far as the DA taking legal action, that is the responsibility of the federal chair, which is Helen Zille, and also we have not had that engagement. So now that is that. So basically then he then threatened, he goes further on to threaten, as I said, it's a veiled threat, because he did not say they will pull out. Neither did he make a threat at this, a significant threat at that press briefing that they will pull out. But the biggest threat that he did issue at the press briefing is that if they proceed with what they are doing without engaging us, finding a political solution around it, we will then wait for the time of budget, we will then wait for the time of adoption of the medium-term development plan. And he also says that we have to agree on issues before we even go to the government lekgotla. Because you know what is currently taking place now is the ANC is at its political lekgotla, taking a position of which they will go to the government or cabinet lekgotla to then present. And that is where also there will be a stalemate to say what you are saying we do not agree with, which will also, as I said, bring about certain interruptions in the operations of the state.
This is not the first time that we see this kind of discontent within the government of national unity. And every time we've seen this with the Bella Bill as well. I will ask this again. Will this act then be the nail in the coffin of this ANC-DA marriage? Or can we see the two parties finding some kind of common ground?
All right. So what I foresee will happen is that they will find common ground. What do I base that on? But it is important that we remind viewers at home that this bill is actually a review of the Expropriation Act 63 of 1975, which was problematic in terms of articulating how Section 25, subsection 2A, B, and maybe C of the Constitution must be implemented. So this bill was to say that let's review the old bill of Section 1975 so then that we iron out any issues related with that. So that is basically that. So it's just to give proper procedure as to how Section 25 must be implemented. So there is nothing new here. And yes, then the second issue is that when the DA had a problem with the Basic Education Laws Amendment Act, it was not again for the entire document, the entire act, but sections of the act. When the DA had a problem with the South African Broadcasting Corporation Bill, or the SABC Bill, that is as it's commonly known, it was again not because of the entire document, but a section thereof. Now, it's the Expropriation Act, it's sections thereof. When it comes to the National Health Insurance Act, it's sections thereof. So when we look at the Basic Education Laws Amendment Bill, the Bella Bill, those sections that they had problems with, at first they were put in abeyance, and later they had some agreement with as far as implementation is concerned, and they agreed. So what I foresee will happen with this Expropriation Act is the same, is that they will sit and discuss Section 7, Section 8, Section 19, and Section 21. And then develop a position around it as to far as ironing out what the DA alleges is policy incoherence, and what that is done, they will continue then implement. Because, as I said, fundamentally, it's not different from 1975 Act, and it's still not a constitutional amendment of Section 25, which says that at 25 subsection 2 B, that there must be compensation. Yeah, so this one also says that there will be compensation, but how do we get to compensation when we expropriate? This is how we will go. So there's nothing really fundamental here, and there's nothing really that prohibits the DA from continuing. Maybe the other, if you look at also now other political parties, the statement issued by the EFF, they are also saying that this is really, there's nothing fundamental here. There's no change here. The MK is saying the same. If you look at the statement or read the statement that was issued by the IFP, fundamentally they are also saying the same thing. So all of these guys are fundamentally saying the same thing. It's just ironing out those sections and they'll be free to move.
Bongani, thank you very much indeed. We do appreciate your time.